When it comes to some of the most significant events in American history, the presidential election of 1800 definitely makes the list. John Adams, a Federalist, and Thomas Jefferson, a Democratic Republican, had once been close friends. But their differing opinions on the role of the federal government had caused them to become bitter rivals.
Their difference really was about the role of the national government and what the new nation should look like. President Adams and the Federalists believed in a strong central national government. President Jefferson, on the other hand, believed in a loose confederation of states bound together by common interests like trade. It's a little bit like if you've ever had a disagreement with a close friend or a boyfriend or a girlfriend, you know that sometimes those disagreements can be the most difficult and the most emotional. And I think that was a little bit what it was like for Adams and Jefferson.
The election of 1800 resulted in a tie in the Electoral College and ultimately led to a constitutional amendment. But it also set the precedent of the peaceful transition of power from one political party to another, which was pretty amazing because these two parties despised each other. In fact, the hostility between the Federalists and the Democratic Republicans was so intense, it actually played a role in the famous and fatal duel between Alexander Hamilton and Aaron Burr.
We talk about how polarized politics is today, but it was even worse then. Back and forth, the attacks were vicious. By modern standards, we would consider them probably out of bounds.
The disagreements between Adams and Jefferson and their respective parties verged on violence. There was talk of secession. It was an absolutely toxic election.
Even though Adams and his Federalist Party had lost the election, Jefferson and the Democratic Republicans would not take office for another 4 months after the election. During this lame duck period, the Federalists took steps to ensure their party would still have a role in the American government.
The first thing that the Federalists did was to pass the Judiciary Act of 1801, which had a number of effects, but the principal effect was to establish a great many more federal judges. It created an intermediate layer of courts between the district courts and the United States Supreme Court, and of course Adams and the Federalist-controlled Congress packed all those offices with Federalist judges, all of whom were appointed for life. The second thing they did was pass what was called the Act Concerning the District of Columbia, which created a number of judicial offices, mainly what are called justices of the peace for the District of Columbia. And again, they began frantically rushing to fill those positions with loyal Federalists.
Legend has it that on his last day in office, John Adams worked until midnight, making sure all the commissions for the newly appointed Federalist judges were signed. The truth is probably a little less dramatic, but the rumor stuck, and soon the new judges were being referred to as the Midnight Judges.
Jefferson complained that the Federalist Party was basically building a fortress in the federal courts so that it could go on essentially employing its own policies through the judiciary, and Jefferson was very indignant about that.
He was absolutely furious. In fact, he later, many years later, wrote a letter to President Adams' wife saying that in their entire relationship, all those years they had known each other, Adams had done only one thing that really offended Jefferson, and that was the appointment of those midnight judges.
I did consider his last appointments to office as personally unkind. They were from among my most ardent political enemies, from whom no faithful cooperation could ever be expected.
The person in charge of delivering the commissions was the Secretary of State, John Marshall. Incidentally, Marshall had been appointed Chief Justice of the Supreme Court while still serving as Secretary of State. While the majority of these so-called midnight judges received their commissions without any trouble, Marshall was short-staffed, so he asked his brother to help deliver the remaining commissions. It wasn't until Thomas Jefferson took office that it was discovered that some of the commissions had never been delivered.
The person who discovered the undelivered commissions actually was President Jefferson himself. For reasons we don't know, he had decided to take a walk over and visit the State Department, and while he was there, he noticed a stack of envelopes on a desk. And he looked down and opened one and realized that they were undelivered judicial commissions for appointments made by President Adams.
William Marbury was one of the midnight judges. He had been appointed by John Adams as Justice of the Peace for the District of Columbia. When it became clear that the new Secretary of State, James Madison, was not going to deliver Marbury's commission, John Marshall ordered him to explain why. Madison never responded. But the new Congress took things further.
After Jefferson does take office in 1801, Congress, now controlled by his own party, repeals the Judiciary Act of 1801. And then they pass another Judiciary Act of 1802, eliminating some of the positions which had been created in 1801. And then one of the things that they did was to suspend the Supreme Court for a year. And so there is a real threat that if the President and Congress have the authority to suspend the court, or, as seems to be the case in the Marbury instance, that the President has supposedly ordered his Secretary of State to not obey a mandate from the Supreme Court, then one can see what would happen as the Supreme Court's importance in our constitutional system would simply disintegrate.
When the Supreme Court returned in 1803, Marbury versus Madison was the first case it heard. It would turn out to be one of the most important cases in Supreme Court history. Remember, the Federalists and Democratic Republicans were bitter rivals, and the issue over the midnight judges had caused even more political tension between the parties. But the court had to make an impartial ruling based on the Constitution. In order to do this, they had to answer some fundamental questions.
The first question we have to ask and answer is, does Marbury have a right to his commission? The second question is, if he has a right, does he have a remedy?
With respect to the first question, the decision was fairly simple. The answer was yes, Marbury had a right to the commission. He was appointed in a valid exercise of presidential power. He was duly confirmed by the United States Senate, and his commission was signed and sealed by the Secretary of State. So the Supreme Court had very little difficulty in saying that he was entitled to the commission. With respect to the second question, whether he had a remedy, again, this gave the court very little pause. There's an old maxim in the law that says every wrong has a remedy. And under applying that maxim, the United States Supreme Court said, yes, if he's entitled to the commission, the law surely must afford him some remedy.
At this point, it seemed as if the court would rule in Marbury's favor, but things didn't end there. There was still one more very important question that needed to be answered.
And the final question is, if he has a remedy, is that remedy a court order granting him his commission? Has he come to the right place? Does he have a right to obtain that order from the Supreme Court as a matter of original jurisdiction, or should he have started out in a lower court?
And suddenly, Chief Justice Marshall veers off into this unexpected territory that none of the parties and none of the lawyers ever raised, that was never discussed in oral argument, and says, oops, we don't have power. We'd love to give you your writ, but you're in the wrong court. We don't have the power to do it. So it was a shocking and unexpected development for everyone concerned.
So, even though the court agreed that Marbury had been wronged and he should have received his commission, he ultimately lost the case. Marbury had claimed that a section of the Judiciary Act of 1789 gave him the ability to bring his case directly to the Supreme Court, skipping all the lower courts. But the Supreme Court ruled that section of the Judiciary Act violated Article 3 of the Constitution.
Marshall says, no. What do we do when we have a statute that seems to be in conflict with the Constitution? What do we do then? And that's where Marshall made his famous argument in favor of judicial review.
In his opinion, Chief Justice Marshall defined judicial review when he wrote,
"It is emphatically the province and duty of the judicial department to say what the law is."
And so one might say, on the one hand, what is meant by saying the judiciary's job is to say what the law is that is its only job. That the only thing it does is to articulate a reading of legislation or a reading of the Constitution.
And if you have a dispute that comes to the court, and one law that is involved is a statute, and another law that is relevant is the Constitution, you have to apply them both. And because the Constitution is the supreme or the superior law, in the event that there is a conflict, the court has to honor the Constitution and disregard or invalidate the law the act of Congress that is in conflict with that.
This was the first time the Supreme Court had ruled an act of Congress unconstitutional.
Marbury was John Marshall's statement to the President and Congress that we're not going to sit on the sidelines and defer to you anymore. We understand that up until now, the Supreme Court has not played any role in our government, and that stops today. We will no longer defer to the legislative branch. We will no longer defer to the executive branch. We intend to assume our co-equal role as the important third branch of American government.
I think what the American framers had in mind really is what Marshall is suggesting here in Marbury, and that is that when the court exercises the power of judicial review, it's not asserting that it is superior to either of the other branches. It's simply saying that the Constitution is superior to either its own view or the views of Congress.
Since Marbury versus Madison, the doctrine of judicial review has become a cornerstone of American constitutional law.
We look to the Supreme Court to resolve many, many issues of great concern with respect to both the constitutionality of congressional laws, state laws, and administrative or presidential practices. Marshall was the one who began that with Marbury versus Madison.
By the time the Supreme Court had ruled on Marbury versus Madison, John Adams had retired to his farm in Massachusetts. As for Thomas Jefferson, he went on to serve 2 terms as president, followed by James Madison, who also served 2 terms. And Adams and Jefferson eventually renewed their friendship, often writing letters to one another. They both died on July 4th, 1826, just hours apart. But what about William Marbury? Well, he never received his commission as Justice of the Peace, and not much was written about him after the case. But his name went into the history books, right along with Adams, Jefferson, and Madison, something that probably wouldn't have happened if he hadn't been the plaintiff in one of the most famous cases in the history of the Supreme Court. And John Marshall's career as Chief Justice was only beginning. Marbury versus Madison was just the first of several landmark cases that would come before his court.